Hello, my name is Darnyell Stephens, and I go by D. I am presenting my capstone today on the inadequacy of funding and policy problems for students with disabilities in public schools. My research specifically focuses on how Maryland establishes policy and funding for special education and the critical components in understanding the challenges that public school districts face in and around the United States, but specifically in Maryland. The purpose of this study is to examine how state funding formulas impact students with disabilities across the United States. I'll go into further details by analyzing Maryland's funding formula and how it affects access to services for special education students. Specifically, I'm looking at how funding influences equity, educational outcomes, and access to required support services. In my research questions, I asked, do all U.S. states public schools have a different standard of funding for disabled students? And how does this standard of funding affect services for these students? Before I get into my research, I would like to introduce you to some key terms that you will hear me mention throughout my research. The first is policy, as it refers to the actions created using guidelines to adopt laws for local, state, and federal governments regarding the public school system. Next is funding, which is the money that is allocated to support educational services for all students in the system, public school system. Then there's educational equity, which means giving every student equal and fair access to an education regardless of their social, economic, or disability background. Next is students with disabilities, which are individuals with a physical or mental disability that limits their learning due to a physical or mental impairment of life activities. And finally, public school system, which is a government funded program that provides instructional education to all students in the specific state and local districts based on state and federal laws. In the United States, special education has faced significant scrutiny because of its funding challenges. As I look at case study from Maryland's public school system, this paper discusses the funding challenges for special education, which includes funding disputes. To set the background for understanding special education needs, this paper engages in some legal analysis and historical court cases, such as Mills versus Board of Education of the District of Columbia, that are important to help understand the free, appropriate public education policy and the understanding of the Individual with Disability Education Act, known as IDEA, and the effects on state level funding and support services for students with disabilities. After engaging with legal cases and discussing the federal policy, this paper then focused on specifically on Maryland, which has higher levels of special education funding challenges as the legal context moves to state level programs such as the Curran Commission, which was passed to reform Maryland's educational system through policies and funding. With the passing of Kerwin program in 2020, this paper argues that there are still significant disputes and challenges with executing these improvements, particularly regarding the allocation of resources for special education services. As we explore this paper, it will show the ongoing struggles that the special education system lacks and the need for full transparency with solutions to ensure that fair access to education for all students in the United States. A research study conducted by West Ed in December 2019. A research study was conducted by West Ed in December 2019. The Maryland State Department of Education, known as MSDE, contracted West Ed to study the IEP process for Maryland Public Schools. West Ed looked at the adequacy of the public school system by focusing on educational funding for students with disabilities in Maryland Public Schools. The reason for the study was to evaluate the quality of the educational service and funding appropriateness for students with disabilities. The study focused on three main topics: assessment of technical assistance with MSDE, current funding and staffing patterns, and recommendations for adequate funding levels for special education. West Ed's study looked at Maryland public school system and determined that a little over 97,000 students had IEPs from 2017 to 18. Which found a little over 5% increase from 2013 to 2014 school year, with approximately 11% of the student population in Maryland schools. The study also showed that students with disabilities, compared to their non-disabled peers, were found to have a higher academic gap based on standardized testing. West Ed found that Maryland spent $1.4 billion in 2017-18 school year on special education students, which comes out to approximately a little over $14,000 per disabled student, but found that a large majority of the funds were used towards salaries. The study recommended that $2 billion. The study recommended that $2 billion over the next couple of years would be needed to help with the inequity between disabled and non-disabled students, to help them achieve success as their peers, and gave recommendations for MSDE to use a different funding model for students with disabilities based on the academic needs, which will help with academic achievement. The study findings also indicated that MSDE should implement a new funding recommendation and monitor this implementation over the next couple of years so that it can help to improve students with disabilities' academic achievements. The framework for funding and policy includes the Individual with Disability Act, again known as IDEA, which mandates federal support for special education, yet there are significant funding shortfalls. When Congress passed the Individual with Disabilities Act, IDEA, in 1975, it required public schools to provide free public education to all students from ages 3 to 21 with disabilities. Over recent years, the federal government has helped with additional costs to these states through applying for grants. IDEA allows states to cover the additional costs associated with special education by providing states with grants equal to the overall number of students with disabilities multiplied by 40% of the national average per pupil expenditure. However, the current funding is only at 13%. The state of Maryland educational program bills special education services through Medicaid. for occupational things for like occupational therapy, service coordinator, speech pathology, physical therapy, and counseling for those funds and counseling. And those funds are distributed to each district to use at their discretion. Maryland Public School continuously face ongoing issues with special education funding at both the state and local levels, creating disparities by not allocating additional funds for special education. The Curran Commission addresses legislative history and policy goals, as well as controversial and funding disputes that impact local education agencies in Maryland. The General Assembly created the Curran Commission on Innovation and Excellence in Education, which was established to reform Maryland's educational system. Its purpose was to collect recommendations on how to prepare the Maryland education system through a multi-year research project to develop funding and policies to change the educational system in Maryland. In 2020, after an intense battle with Maryland legislature, the bill passed, yet disputes continue about how effectively it allocates funding, particularly for special education services. Hogan vetoed the bill on May 7, 2020, because Baltimore City Public Schools failed to conduct assessment for thousands of students referred for evaluation for special education services. The legislators overrode his veto. Although most legislators wanted this bill to pass, others felt it was a repeat of the casino bill passed to use the funds for education. Once the law was passed, it was discovered that additional funding to local educational agencies expected from the state never happened. Casino revenues have not led to major increase in state school funding, as many Marylanders expected it and also voted for it. According to the Maryland Association Boards of Education, while casino revenues went into educational trust fund, which can only be used for public education, nearly the same amount of existing funding was shifted from that education money to other parts of the state's budget. As of today, the Curran Commission is having funding challenges because when this bill passed, it didn't address the funding sources to implement the policies that what it was set out to do. It had 4 goals, and they were construction for additional classrooms and the expansion of pre-K, classroom modification to accommodate instructional challenges, to expand career and technical education, create additional staffing for special education students and English language learners, and raise the minimum salaries for teachers to $60,000 starting in 2026. Important legal proceedings such as Mills versus Board of Education and Brown versus Board of Education have shaped the landscape of educational rights for students with disabilities, influencing state-level outcomes in Maryland. In the court case Mill versus Board of Education, District of Columbia in 1972, 7 plaintiffs were denied a free, appropriate public education due to the District of Columbia failing to fund schools for students with special needs, which in turn students were excluded from schools. The outcome in this case was that the court ruled that students were to be educated even if the student or family was unable to pay. Due to the significance of this case, the blueprint for Maryland Future Act, House Bill 1300, known as the Curran bill, ended with Baltimore, our own Maryland, Baltimore City Public Schools. This bill, Maryland's Future Act, House Bill 1300, known as Curran and the Curran bill, ended with Baltimore City Public Schools being placed on a consent decree requiring that the school system comply with all state and federal laws with the state of Maryland, threatening to withhold funding from Baltimore City public schools for not complying. Girl, if I keep sending you to there, that is a reason. Now I had to stop my stuff. I don't even know where the fuck I'm at. Oh, yes. I'm recording. I can't. If I keep calling, if I keep sending you there, I'm recording. I can't talk. I'm recording. I'm recording, and you keep. I will. I'm I'll call you back. All right. Also, in Mills versus Board of Education, it found that this could have been avoided if the school district had adhered to the ruling of Brown versus Board of Education in 1954, well-known case. If the District of Columbia school system had provided a free and appropriate education to the excluded special education student, then this case would not have been in existence. If the state of Maryland had provided significant funding to ensure programming, education, and the training for Maryland students, the Future Act HB 1300 would not have been passed. Although at the time Hogan disagreed with the bill, but it still passed in the Maryland State Senate while he was in office, but he failed to fully fund the bill in his budget. The state of Maryland was insensible to the needs of Maryland's. The state of Maryland was sensitive to the needs of Maryland students. Future Act HB 1300 will provide a holistic approach for students in Maryland. If the Baltimore City Public School had followed the law and provided the students with initial assessment for special education, the school district would not have been in need. Baltimore City Public Schools was sanctioned to be under the consent decree for 3 years, but due to the district's failure to prepare and show the court a solid action plan, the district remains under the consent decree for an additional 9 years. Federal policies affecting special education included the IDA amendments, the Americans with Disabilities Act, and the Every Student Succeeds Act, all of which aim to ensure educational access for students and disabilities. The Americans with Disability Act was amended in 2008 to revise the definition of disability. Individual education plan, as you heard me speak, is called the IEP, individual education plan. That's called the IEP. Teams had to determine how the student's disability limits their major life activities. This amendment gave families the right to request assistive technology and any other reasonable accommodation needed. Discrimination based on disability was also added to protect all special education children. Behavioral intervention plans or modifications were a part of this amendment. Section 504 accommodations were redefined in this amendment. Accommodations in 504 plans included, but are not limited to eyeglasses, prosthetic limbs, cochlear implants, hearing aids, and mobility devices. The No Child Left Behind Act, known as the NCLB, was enacted to ensure that special education students and disadvantaged students have a quality education. Many families of special education students believe that the law helped their loved ones to be able to live up to the potential and demonstrate higher achievement. The Every Student Succeeds Act, known as the ESSA, was enacted to make public schools accountable for how students learn and achieve. The Every Student Succeeds Act replaced the No Child Left Behind Act. Each state educational board could decide how to educate its special education population students by using a framework provided by federal government. Four key disadvantaged groups were highlighted under the ESSA, and they are students in poverty, minorities, special education students, and students with limited English language skills for special education students. The part of ESSA that affects them in the academic standards, annual testing, school accountability, goals for academic achievement, and plans for supporting and improving struggling schools. In light of ongoing concerns regarding special education funding under the current administration, special education funding continues to be a concern. In fact, due to recent layoffs from the Department of Education, which also affects staff under the Office of Special Education and Rehabilitation Services, this department in the Department of Education has a 15 million budget and is responsible for ensuring compliance with Individuals with the Disability Act. Unfortunately, these federal employees were all let go under the current administration. Because of this, there are concerns about how compliance will be guaranteed for disabled students. Although the Office of Civil Rights investigates complaints of discrimination, they too have seen a reduction in staff. It is said that it is said that this very issue challenges federal law and its protection for these students. In fact, many attorneys have advised their clients to stop filing complaints at the Office of Civil Rights due to the reduction of staff, which possesses a problem and effectively addressing issues regarding special education students. New Hampshire Senator Maggie Hassan shared her concern about cutting more than 120 positions within the Office of Special Education and Rehabilitative Services. She too is a parent, and this affects her son, who has cerebral palsy. As a senator and a parent, her concerns are valid. So she advocates for funding to remain in place for disabled students because she too relies on these services that are provided for disabled students. The discussion on funding includes private school placement and the importance of providing a free, appropriate public education for all students. If a parent has a child with a disability and wants to send that child to a private school, there are instances where they could, and the district will have to pay for it. If a child has received services for a special education, IEP, in a public district, and then the parent decides to enroll the child in a private school without any permission or a referral from the public school district, an administrative court law judge, called a ALJ, can make that district pay the cost of that child's enrollment if the district had failed to make free, a free, appropriate public education available to that child in a timely manner. So basically, if that school district did not give that child an IEP in a timely manner, a parent can therefore choose to enroll that child in a private school. And then the district could be made to pay the child's enrollment if the district had not made that free, appropriate public education available to that child in a timely manner, is what I just talked about. Another way a child with a disability could go to private school is to apply for the broadening options and opportunities for students today scholarship, known as BOOST. This program was funded by the legislature through the state's budget of $10 million. House Bill 1213 was created by Delegate Haynes and other legislators and backed by Hogan during the 2016 legislative session. The scholarship is for kindergarten through 12th grade students in Maryland who would like to attend non-public schools, such as private or parochial schools. Boost was created to help parents select a non-public school for their children that best fits the children's educational needs due to the Maryland public schools failing. Boost is a state-run, state-funded scholarship program to provide education options to income-eligible Maryland children, including students with disabilities. The IDA outlines dispute resolution procedures, which are crucial for addressing conflicts in special education services, and the role of the administrative law judge and the role of the Office of Administrative Hearings is vital in this process. If a parent with a child who has a disability disagrees with the child's IEP, a parent may file a complaint and go through the mediation process. If a parent decides to go through the mediation process, they may be asked to sign a confidentiality form. Parents also have the choice to hire an attorney, a private attorney, or look into pro bono legal services. The mediation is conducted by the Office of Administrative Hearing, known as OAH, with a qualified mediator who conducts the mediation. There is no cost to the parents or the school district. The parents send their complaint to the school district asking for mediation of the child's IEP. Parents may bring their attorney or counsel to the mediation, and it typically occurs within 20 days of filing their complaint. The State Department states that the proceedings are closed session and that mediation is confidential and cannot be used as evidence in any court proceeding. If an agreement is reached, then both parties must sign. At any time, the parents have the right to stop the mediation and take their case to a court hearing. Complaints filed for special educated students have grown significantly in Maryland. In 21-22 Maryland school year, compared to the surrounding states, has had many filings of dispute resolution complaints than other surrounding states. Maryland had 155 complaints filed, and 45 of them were dismissed. Pennsylvania had 78 complaints filed, and 52 of them were dismissed. Virginia had 72 filed, and 104 carried over from the current and previous year were dismissed. DC had 26 complaints filed and 5 dismissed. Lastly, Delaware had 8 complaints filed and none dismissed. Of the mediations held in Maryland for special education children, again, we came in with more compared to our surrounding states. Maryland has 79 mediations for 21-22 school year, and 38 reached an agreement. Virginia had 22 mediations, 12 reached an agreement. Pennsylvania had 9, and 3 reached an agreement. DC had 9, and 8 reached an agreement. Delaware, coming in again with fewer, had 3, and all 3 resulted in an agreement. And carryover from prior years, Maryland had 6 disputes go to hearing, but 220 were withdrawn or dismissed, which seems as if they were carried over from the prior year. This time, DC had 40 complaints go to hearing, and 142 were dismissed or withdrawn. Pennsylvania had 50 go to hearing, and 807 withdrawn or dismissed. The lowest was Delaware complaints that went to hearing. So compared to Maryland's surrounding areas, it ranked highest with complaints, disputes, mediation, and hearing. Advocacy organizations play a critical role in supporting students with disabilities, emphasizing the need for equal access to education and effective mediation practices. There are organizations to facilitate or mediate matters on behalf of the child in special education. A mediator establishes ground rules from the beginning and gives each party a chance to respond so that each party communicates its wants effectively. Education of Advocates of America is an organization that helps parents with children to advocate for services that their children receive or should receive. This organization helps parents make important decisions regarding their child's IEP. These parents go into their child's IEP meeting with knowledge of what services their child is entitled to. The organization has an advocate to accompany the parents to the IEP meeting to help them get the best possible services. This service is not free, but has payment plans and is probably less than an attorney. The consultation is free, and sometimes parents do not need to go any further based on their conversation. The advocate talks about your rights as a parent and works with you on on strategies and goals based on your child's needs. Parent Plus is another Maryland organization that uses facilitators to help reach some resolution for children with IEPs. This process is free through the Community Mediation Centers known as CMM and is offered by the Maryland State Department of Education as an independent organization. With this type of mediation, all parties must agree to use a facilitative mediator. This organization works with many school districts, MSDE, and local centers to help facilitate these disabilities. To improve the IEP process for special education students, the Maryland State Department of Education must implement the recommendation from West Ed study and ensure transparency and funding allocation. Although West Ed gave Maryland the solutions of needing to address this funding to improve the IEP process for special education, fulfill its obligation to provide 40% per pupil funding for special education as mandated by the IDEA, ensure that special education students funding go to services to help these students, and enforce policy and laws set in place to ensure that every child has a free public education. With the latest news of the U.S. Department of Education is planned to dismantle the entire department, how will our disabled students be protected? Although the administration says that schools will still receive federal funds and that the states will have more control over the funds, which questions will the funds go to disabled students and helping them to succeed? The administration plans to have the Department of Labor take over distributing funds, but the Department of Education will hold on to the policy duties of education. Education Law Center's February 2025 edition talked about the impact of dismantling the U.S. Department of Education and the effects that will have on disabled students. If states take over 22,000 complaints, it states that over 22,000 complaints were filed based on disability discrimination in schools alone. And if moved, it will cause significant challenge for students seeking fair outcomes. The article goes on to say that dismantling the department will hurt disabled students by having a lower number of trained professional special education students, disrupt the IEP process with this significant delays, reduce classroom inclusiveness, and pay for additional services also due to Medicaid cuts. At this time, there is no indication when this will take place because Congress has to vote to dismantle the U.S. Department of Education. But the president has the power to shift, reorganize, or transfer staff and duties to other government agencies. Unfortunately, state school educators and policymakers have had no insight into what will happen with the Department of Education and have not been included in the planning and decision-making process, which creates a barrier of the uncertainty in the budgeting, staffing, and ensuring protection against students with disabilities. I would like to conclude my research by stating that Maryland does not do enough to fund our public schools to improve special education. Based on my analysis, due to funding gaps, achievement disparities, and high volume of disputes, which point to inadequate resources. And yes, students with disabilities should be allowed to attend non-public schools due to the inadequacy of public school funding and achievement. In order to strengthen the public school system, we need to use the funding for what it was intended to do rather than diverting it to other sources. This will invest in our special education student population and allow them to achieve goals as their non-disabled students do, and to have a free, appropriate public education. Thank you.